In the matter of Raja Khan versus State of Chhattisgarh, the Supreme Court said that it is of the view that the appellant accused is entitled to the benefit of doubt. Accordingly, the appealed judgments under the conviction of the appellant accused under Section 302 and 201 of IPC were set aside and the appeal was allowed. The respondents were directed to release the appellant accused forthwith unless and until he was in detention in another matter. The case of the prosecution was that Neeraj Yadav left his house on 29 November 2013 but did not return home, and a missing report was lodged by the father of the deceased Premlal Yadav on 30th November 2013. Chandrasekhar Verma, PW1, informed the police on 1st December 2013 that a dead body had been found floating in a pond of stone quarry in village Dondakela Matia, and upon receiving the information, police personnel of police station Vidhan Samar reached the spot. Thereafter, a MERG intimation was registered on 2nd December and body of the deceased was sent for post-mortem examination. It was concluded that the death was homicidal in nature. Subsequently, FIR was filed at PS Vidhan Sabha, District Raipur. The dead body of the deceased was identified by Balram Yadav, who was cousin brother of the deceased. During course of investigation, it was found that the accused had borrowed money from the deceased, and dispute has arisen between them with respect to refund of the borrowed amount. It was the case of prosecution that the appellant, along with co-accused Tarachand Verma, had taken the deceased on the intervening day in an auto to the place of incident, assaulted the deceased with an iron pipe and battle axe, and thereby committed his murder, and with intent to cause disappearance of evidence, smashed his head with stone, and after removing his full pant, tied a rope around his waist and thrown the body in the water of quarry number 1. Appellant argued that the perusal of testimonies of PW 22 and 26 reveal that articles such as stone and gandasa were recovered from the bottom of the Kachna pond at the instance of police officer and not of the accused. He stated that the test identification parade of the two gold chains purportedly belonging to the deceased was questionable, as the place of recovery, this rooftop of the house of the accused, was an open space accessible to public from outside, and the same was evidenced from the fact that recovery was made by climbing onto the rooftop from the outside the house. According to him, the recovery of gold chains was fabricated, as the witnesses Tirth Dhruv and Bhupendra Dhruv never saw the police officers recovering the same from the house of the appellant. Further, neither the testimony of the witnesses nor the IO mentioned that the accused was accompanying the recovery team or the recovery was made at the instance of the appellant. Respondent Mr. Praful Bhatt, learned senior counsel, argued that the recovery of the stone which was used for commission of crime had been made at the instance of the accused. According to disclosure statements of the accused, the stone was thrown by him in the Kachna pond, who is the witness to the memorandum statement and Caesar memo, had duly supported the same, which was PW22. As per the FSL report, human blood was found on the seized stone. He further stated that on the basis of the disclosure statement of the appellant accused, two gold chains belonging to the deceased were also seized at the instance of the appellant accused from the roof of the house of the appellant, which had been duly proved by PW22. Additionally, he pointed out that the seized gold chains were identifiable by PW2 by memo of identification, which had been duly proved by Gopi Sahu. Having heard learned counsels for the parties, the entire case of the prosecution rests on the circumstantial evidence, as there is neither any eyewitness nor any judicially admissible confession, the Supreme Court observed. It is well settled law that where the case rests entirely on circumstantial evidence, the chain of evidence must be so far complete such that every hypothesis is excluded but the one proposed to be proved, and such circumstances must show that the act has been done by the appellant accused within all human probability. A bare perusal of the testimonies of the said witnesses raised serious doubts regarding the version of the prosecution with respect to the alleged disclosure. The essential ingredients of Section 27 of the Evidence Act are threefold. The information given by the accused must lead to the discovery of the fact which is the direct outcome of such information. Only such portion of the information given as is distinctly connected with the said recovery is admissible against the accused. The discovery of the facts must lead to the commission of such offense. The diver who allegedly recovered the stone and gandasa from the Kachna pond in his testimony admits that he recovered the said items upon the instruction from the police and from the place told by the police without making any reference to the presence of the appellant accused or the fact that the said items were recovered upon being pointed out by the appellant accused. The fact that the items from Kachna Pond were seized upon the instructions of the police is corroborated by the statement of Tirath Dhruv, who unequivocally states that it was the police who instructed the divers to go into the pond and take them out. There are also glaring inconsistencies in the tip of the gold chains, rendering the proceedings unreliable and inadmissible, as Anwar Hussain, who identified the gold chains, has consistently denied that Purnima Yadav, wife of the deceased, identified the two gold chains, that the said gold chains belonged to the deceased. He further denied that six more similar chains were placed alongside the two gold chains. This fact has been corroborated by the testimonies of Gopi Sahu and Jugal Kishore Verma, wherein they have stated that only two gold chains were placed for identification. Further, the testimonies of witnesses reveal that the two gold chains do not bear any distinguishable mark or properties, and no identification mark or properties were disclosed by Purnima Yadav prior to identification proceeding. Purnima Yadav states in her testimony that the two gold chains were handed over to her at the police station on 10 December 2013 in exchange for receipts, bill, invoices a day prior to the conduct of the tip of the gold chains. The court was of the view, thus, that the courts below were not justified in disregarding the glaring inconsistencies with respect to the recoveries made by the police pursuant to the alleged disclosure made by the appellant accused. Consequently, the manner of recovery and preparation of seizure memos raises grave doubts about the version of disclosure and recovery put forth by the prosecution. Keeping in view the aforesaid, the court was of the opinion that the prosecution has failed to prove the chain of circumstances leading to the guilt of the accused beyond reasonable doubt.